This morning, hear oral arguments in the case of Rivenbark versus Discount Drug Mart. Each party will have 15 minutes in which to present their case. If you're the appellant, you may reserve up to 5 minutes for rebuttal. If you are the appellant, you want to reserve that time, let me know when you come up to the podium. I'm keeping track of the time, and we'll keep you apprised of passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs, and we are ready to proceed when you are.
Thank you, Your Honor. My name is Kathleen Amerkanian, and I represent appellant Clifford Rivenbark, and I would like to reserve 5 minutes for rebuttal. This appeal concerns the a defense verdict in an employment discrimination case. The cause of action submitted to the jury was one of disability discrimination in the form of retaliation. In this case, Clifford Rivenbark had been an employee of Discount Drug Mart for about 13 years. His termination came in August 2012, and it came under the following circumstances. He had a meeting after many, many years of trying to get a disability accommodation, trying to work through the interactive process with Discount Drug Mart, and being unsatisfied with the feedback he was getting from Discount Drug Mart. He wrote a letter complaining of the lack of a reasonable accommodation, complaining of the lack of the interactive process required under the disability discrimination laws. He went in to meet with the human resources manager, read the letter. He did not raise his voice, did not personally threaten anybody. There was no shouting match or anything like that. He read the letter, he left. 3 days later, he was handed his termination notice. The jury in this case was misled as to the law and to the facts. The ways in which the jury was misled was, number one, the jury was instructed by the trial court that they were not to consider bipolar disorder in any fashion. Now, bipolar disorder was not the disability for which Cliff Rivenbark was seeking an accommodation. He was actually seeking an accommodation due to a leg injury.
So then why should they have been allowed to consider bipolar disorder?
They should have been allowed to consider bipolar disorder because it had been an integral part of Cliff Rivenbark's interactions with his employer for about a decade. Dr. Sang was Cliff Rivenbark's psychiatrist, and he testified at trial as a fact witness as to his treatment of Cliff Rivenbark, the interactions, the symptoms he observed. Discount Drug Mart witnesses also testified at trial as to their familiarity with Cliff Rivenbark's bipolar disorder, some of the behaviors that it resulted in, such as speaking fast, such as arm gestures, such as sweating when he was talking. So the jury's inability to consider bipolar disorder in any fashion inhibited the jury's ability to evaluate the credibility of Discount Drug Mart witnesses when they suddenly felt that these same symptoms that he exhibited were a threat and were intimidation.
Have you ever asked for any accommodations before as a result of having bipolar disorder?
Yes, there had been an interactive process with relation to the bipolar disorder back, I believe in 2003 or 2004, actually it may have been earlier, and there had been an accommodation reached with regard to the bipolar disorder. Mr. Rivenbark was not claiming that Discount Drug Mart failed to accommodate his bipolar disorder. He was stating that Discount Drug Mart was not providing an adequate, reasonable accommodation for his leg injury. There was no dispute that the leg injury was a qualified disability under the relevant statutes.
So it goes towards credibility and explaining the disputes said to the point where somebody was threatened or frightened, is that where the bipolar testimony would be relevant?
I believe so,
Well,
and
then, isn't it a problem that there was no expert called to explain bipolar, the condition of bipolar, and this is how it relates to how your client, Mr. Rivenbark, presented himself that day? There was nothing to connect that, was there, in the testimony?
the reason I don't believe that that was an issue is because there was no requirement in this case to prove that his symptoms were as a result of his bipolar disorder. And what had already been presented through...
His conduct on the day of the meeting was not a result of his bipolar disorder, is what you're saying?
No, what I'm saying is that the fact that Discount Drug Mart was very familiar with this kind of conduct over the years of dealing and interacting with him relating to his bipolar disorder was already established in the record. The doctor testified as a fact witness who could state that this was already, there was an interactive process. Discount Drug Mart witnesses also testified were very familiar with his symptoms. The fact that all of a sudden that same behavior that they had been dealing with for 10 years all of a sudden became a threat on August 9th, 2012 is a credibility determination.
That you should have been able to argue to.
If the jury can't consider bipolar at all, the jury, it's not, this instruction was very broad. It wasn't, don't consider bipolar for purposes of determining whether he was disabled, or it wasn't a limited instruction, it was very broad. They were not to consider bipolar disorder, even to evaluate the credibility of Discount Drug Mart witnesses.
But counsel, didn't your client, as to that particular date and that particular meeting, didn't your client testify opposite of what the Discount Drug Mart person said in terms of how he reacted?
Well,
She said he reacted one way, and for his testimony, didn't react that way at all.
I don't recall specifically the reaction, but I would point out that it was undisputed, even through Lee Ring's testimony, that Clifford did not yell. She conceded that he did not raise his voice. She conceded that he did not personally threaten her. She conceded that the only implied threat was that he would go get an attorney and pursue his legal options. So the fact that she claimed to be intimidated, despite all of that undisputed testimony, it is a credibility determination, but the jury was not able to fully engage in that credibility determination because of the limitation of not considering the bipolar.
But your argument's circular. There was no expert testimony saying if he in fact did act that way, it was because of the bipolar.
Well, I'm arguing that it doesn't matter. It doesn't matter so much as to whether his behavior was attributable to his bipolar or not. The fact of the matter is, what matters here is that Discount Drug Mart was very familiar with this behavior. So whether it's due to bipolar or not is not quite the issue. However, if the jury is not able to consider the fact that Discount Drug Mart was familiar with all this past history and was familiar with it was not disputed that these were symptoms due to his bipolar from Discount Drug Mart's perspective. If the jury's not able to consider that, then how can they make a full credibility determination of what happened on that day? I think the second way in which the jury was misled was the fact that an expert was allowed to testify as to matters that did not require expert testimony. And this is error because the case law is very clear that experts may only testify as to subject matter that is outside the ken or outside of the knowledge of the ordinary juror layperson. In this case, the expert during voir dire, Janet Kilbane, stated she felt her testimony would be relevant and helpful to show that Cliff Rivenbark did not use all the job search tools that should have been available, that he should have used. You know, how to find a job, how to search for a job, whether a job search is reasonable, which is all that one must show when you're talking about mitigation of damages, is not something that requires expert testimony to show.
You have 5 minutes.
Is that for rebuttal or 5 minutes in my primary?
That's your rebuttal.
Okay. And so Janet Kilbane being able to testify as to these matters really usurped the role of the jury. And the danger of her testimony being presented under the guise of an expert who, you know, the juror is going to put more weight in that, was used and fully exploited by the defense when her testimony was used to attack the credibility of Cliff. She was allowed to testify that she felt that he had only applied for one job. And that was based on exhibits that were admitted. The jury, that was the jury's job. The jury was in the position to evaluate his credibility and to determine how many jobs that they felt that he had conducted or applied for and whether that constituted a reasonable job search. I will reserve the rest of my time for rebuttal.
Good morning. May it please the court. My name is Max Dane. I didn't appear on the sign-up sheet, so I'm not sure if I appear, but I am on the briefing. Max Dane with Cabbage Family Law, represent Discount Drug Mart. And I'd like to, before getting into my argument, if I may, I'd like to just touch on a few points that opposing counsel just made, particularly, or some of the back and forth. I believe Judge Teodosio asked, wouldn't the expert have gone to credibility, and why wouldn't you have excuse me, wouldn't the bipolar issue have gone to credibility, and why wouldn't you have had Dr. Singh testify as an expert? That is exactly what the trial court raised when she said, we are not going to talk about bipolar anymore in this case. You didn't bring in an expert. Without an expert demonstrating a causative relationship between Mr. Rivenbark's behavior on August 9th and his bipolar condition, I'm not going to let you talk about bipolar. And opposing counsel embraced that and accepted it, and as is set forth in the briefing, absolutely waived any argument to be raised at this level. And I'd like to get into that a little more, I hope, in the context of the argument. In fact, I think if it's okay, I'd like to jump to that because plaintiff raises the acknowledging that the bipolar issue had been waived. Plaintiff argues that Dr. Singh's notes should have been admitted irrespective of whether the issue of bipolar generally had been waived. And plaintiff argued, I think in the briefs, that there was an objection to the judge, to trial court, removing Singh's or not allowing Singh's notes to go back to the jury. That is inaccurate. If you look at pages 1560 through 1570 of the record, you will see a lengthy conversation specifically centered on Dr. Singh's records. We both had reasons that we may have wanted Dr. Singh's records in, irrespective of whether the bipolar issue was going to remain in the case. Dr. Singh had provided testimony that we felt was helpful, and then it undercut Mr. Rivenbark's credibility on some important questions. And opposing counsel wanted Dr. Singh's records for similar to how opposing counsel has argued here. After listening to this and after going back and forth over 10 pages of transcript, the judge said, listen, I don't think they should be there, and both attorneys concurred. And at page 1570, you will see plaintiff's counsel saying something like, okay, that's fine, they're out, I'm okay with that. There was never an objection raised to that ruling. And I think that that's important. With respect to the argument that was just raised that Discount Drug Mart was encountering the same behavior that Mr. Rivenbark had demonstrated over time since they initially became aware of his bipolar diagnosis in 2002, that is flatly wrong. Witness after witness testified that after Mr. Rivenbark was reassigned to a new position on July 27th of 2012, his misconduct escalated, his rage escalated, and over the next 2 weeks he had increasingly fractious interactions with Discount Drug Mart supervisors and with HR people. I think that that's set out fairly well in the brief. But this notion, and most importantly, Lee Ring, with whom he had his final confrontation, had probably 20 to 25 meetings with Cliff, with Mr. Rivenbark, over the years dating back at least to 2008. She testified with respect to interactions that she'd had in 2008, which were contentious, but which she walked out of without fear, which she never raised any concerns, which didn't become any larger issue. Mr. Rivenbark's conduct changed and escalated after July 27th of 2012, when he was reassigned. The record speaks, I think, fairly clear to that, and I think that needs to be stated in response. With respect to the meeting itself that Mr. Rivenbark had on August 9th of 2012, Mr. Rivenbark testified that he walked into the meeting, he read a letter asking for his rights under the Americans with Disabilities Act. He said thank you, and he left. Lee Ring testified to a 30-minute confrontation, during which at times he read from a letter and at other times he rambled angrily and incoherently. She said she was afraid. She said when she asked him to stop because she was intimidated, he was non-responsive. She asked him and tried to express herself. She had, before this meeting occurred, because of Mr. Rivenbark's kind of escalating anger and misconduct, especially with respect to his interaction with HR people for the 2 weeks leading up to that meeting, after he'd been reassigned, she had thought ahead of time about how she would get out of that room if the plaintiff walked in and trapped her there.
Did she ask for another individual to join her for the interview?
No, but she had said that the testimony is that she'd set up kind of a code that if she, sent out a message that, I'm in here and I need, call me, get me out of here. And the jury did a jury view, a walkthrough, so the jury saw this space, and the jury saw the space as it relates to the workplace, et cetera. And I think that that's important. 9 witnesses, 1,768 pages of trial transcript, a jury view, about 2 weeks or nearly 2 weeks of trial, and the jury determined that Discount Drug Mart terminated Mr. Rivenbark because of his confrontation with Lee Ring. The factual question boiled down to that. Did they terminate Mr. Rivenbark for his conduct during the course of that confrontation? Or did they terminate him because he asked for an accommodation under the ADA? That's exactly what the jury heard, and that's exactly what the jury was asked to opine upon. And that's the verdict that the jury came to, was that Discount Drug Mart terminated Mr. Rivenbark because of his conduct. With respect to Janet Kilbane's testimony, she testified completely appropriately under Rule 702. First of all, it's not true that they didn't know she was going to testify to the reasonableness of Mr. Rivenbark's job search. That's exactly why she was there. She was there as a mitigation expert. Of course she has a different view of Mr. Rivenbark's reasonableness. That's what experts do. They express an expert opinion on a particular series of events And generally, one party has them there because that expert is signifying that, look, this conduct is either reasonable or it wasn't reasonable. And that's exactly what she opined upon. And after voir dire, the court found her to be qualified as an expert. Mr. Rivenbark's counsel tries to turn this on its head and says that Janet Kilbane inappropriately sought to undercut the veracity of Mr. Rivenbark's testimony. That's flatly untrue. She points to, or at least it's a mistake in the law, because she points to case authorities, specifically Hampton versus St. Michael, which indicate that it is inappropriate for an expert to come in and opine on whether a witness was telling the truth. That's not what Janet Kilbane came in to testify about, and that's not what Janet Kilbane did testify. And it's interesting that Hampton rests upon Rassilon versus TJX, which is a 9th District opinion, which similarly establishes that an expert can't come in and tell a jury that, in the Rassilon case, a security guard is lying about what occurred during a detention of a shoplifter. But that's not what Janet Kilbane was there. That's a red herring, and it should be disregarded. Again, the issue in this matter was an issue of credibility. The jury heard from Lee Ring, who testified under cross-examination twice. First of all, she was called on cross-examination. She came back under direct examination, and then she was cross-examined again. And they credited, apparently, Lee Ring's account of what happened with respect to her encounter with Mr. Rivenbark. Now, juries take into a number of, I'm sure, I've tried the case, the jury takes into account a number of matters when it weighs credibility. With respect to Mr. Rivenbark, there was a lot of reasons to question his credibility, and also, conversely, to credit Discount Drug Mart and particularly Lee Ring. Lee Ring had worked as a HR professional for, I think, about 15 years. She testified clearly and plainly that she had never had an experience in which she was frightened or contacted her supervisor regarding some fear or anything along those lines. The executive vice president of Discount Drug Mart, Buddy Gans, the president of Discount Drug Mart, I lost his last name. The executive, Buddy Graff, the president of Discount Drug Mart, Mr. Gans, the HR director of Discount Drug Mart, Janet Sakaro, testified that they heard Lee Ring's account of this confrontation, and knowing Lee Ring and knowing her, the way she carried herself, they believed it. More importantly, Lee Ring wrote a contemporaneous account of the encounter with Mr. Rivenbark. It's in the record. And Lee Ring walked directly down to the office of Bob Wall, who was Mr. Rivenbark's supervisor, or who actually supervised the warehouse. And Bob Wall wrote a contemporaneous account of what he encountered when Ms. Ring walked into his office, tearful, shaking, and as he described it, afraid for her life. The jury heard that testimony, and they heard Mr. Rivenbark's account of that encounter. The jury had a decision to make in terms of who they believed, and they made that decision. With respect to Mr. Rivenbark's testimony, there was some basis to question his credibility. By example, there was an account of him visiting a physician, a Dr. Goss, on July 25th of 2012. You'll see this at 521 through 526 in the record. He told Discount Drug Mart and he told the court that he was there that day because of injuries that he had sustained as a result of the rigors of his work. But when we pulled up Dr. Goddard's records and we showed them to the jury, the records say that Mr. Rivenbark tells me he's here today because he was painting his garage over the weekend, and his back was strained, or there's some physical discomfort. That's important too, because Mr. Rivenbark, throughout the record, in his depositions and testimony at trial, spoke about the rigors and the difficulties which he encountered as a result of the physical nature of his work at the warehouse. That he spent weekends on a couch recovering, and he couldn't spend his weekends enjoying his life with his family. Well, Dr. Kotz's account specifically and directly undercuts that and calls into question his credibility. On August 7th, right in the middle of this contentious period where he's been reassigned, and he says his new job is too difficult and it's hurting him badly, it's killing him, he's raising his voice, he's talking to supervisors and to HR saying, I can't physically do this job and you know it. Right in the middle of that period, he goes to see a Dr. Leaf. And when we read Dr. Leaf's notes, we find that he hasn't come here to talk about an injury. In fact, the notes specifically say, there is no injury. Rather, Mr. Rivenbark is here to inquire as to how a future injury may be treated if in fact he pulls a muscle, and he wants muscle relaxers. There was no injury. He specifically appears to have misled the jury, Discount Drug Mart, and the entire process. There were other stories that the jury heard and which weighed in with respect to Mr. Rivenbark's credibility. There was a story about an earlier discipline incident in which Mr. Rivenbark had been suspended for a period of time. He was invited to come back in and to talk to Discount Drug Mart management before he was allowed to go back to work. It was an indoor meeting. And he wouldn't take off his sunglasses, and he slouched in his chair. And Buddy Graff testified to this, and it bothered them. They asked him, Buddy Graff specifically, asked him, and this is in the record at 1048-1048, listen, Cliff, would you take off your sunglasses? Well, on redirect, Mr. Rivenbark said, the reason I couldn't take off my sunglasses was because I had had cataract surgery. So we looked in the medical record. The cataract surgery was like 8 months beforehand. And we asked Mr. Rivenbark to explain that, and he couldn't. It was another instance of credibility that this jury had the opportunity to hear and to weigh. I'm sorry.
You're out of time.
Oh, thank you very much. Discount Drug Mart would ask that the jury verdict be upheld. Thank you.
Attorney Merrick, you have about 3.5 minutes.
Thank you, Your Honor. Nobody's disputing that this was a long trial and there was a lot of testimony. But let's talk about some of that testimony that the jury heard that was used to try to attack Cliff Rivenbark's credibility. Some of it was irrelevant, prejudicial, and was akin to improper character evidence. First of all, whether Cliff Rivenbark took off his sunglasses or didn't take off his sunglasses in a time period that had nothing to do with the August 9th meeting was an example of something that was brought out simply to malign Mr. Rivenbark. It had nothing to do with the issues in the case at bar. There was testimony that one of the Discount Drug Mart managers...
Was that brought up on cross-examination of him, right? That issue was brought up on cross-examination.
I believe it was through the...
credibility?
For what purpose? I mean, he testified that he didn't take his sunglasses off, and he testified that he had recent cataract surgery. So, I mean, how does that relate?
Isn't that for the jury to weigh the credibility of a witness?
Perhaps, but I want to go also into other instances that relate to that. The testimony that Mr. Rivenbark was making some sort of Johnny Manziel money sign at deposition. The jury heard that. That had nothing to do with the issues in this case. It has nothing to do with credibility. The testimony that one of the Discount Drug Mart witnesses had seen Mr. Rivenbark at a Cavs game after he had been terminated, that also had nothing to do with credibility. That was not something that really had anything to do with a legitimate issue in the case, and instead, it was an instance of bringing in some sort of collateral source improper evidence. Testimony that Mr. Rivenbark had gone to his doctor for various reasons and that the notes had stated that there was no injury, I think that grossly overstates the impact of the notes. The notes never said that he wasn't injured. There was never a doctor writing, there is no injury. The doctor simply documented what they discussed. And whether the doctor had put down everything that they had discussed or not, we don't know because the doctors were not called as witnesses. Cliff was employed by Drugmart for 13 years. For the majority of that time, he had good performance reviews. The effort by Drugmart to sort of apply a revisionist historian's touch to his employment at DDM should not be, is not supported by the record. It's not supported by the objective evidence that was presented, such as good performance reviews, such as the fact that he was every year received his normal pay raises. The only thing that prompted his termination was when he began to have discussions about his dissatisfaction with their failure to accommodate him, which is the definition of retaliation.
Well, the plaintiff introduced the good performance reviews as a,
Yes.
what would you say about this? Go back a little bit if you have time. On the waiver issue as to the jury instruction argument that you have, that plaintiff's counsel pretty much had an opportunity to review with defense counsel in court, and there seems to have been an agreement as to the instructions and no objection. Do you want to address that shortly?
No, just quickly.
Okay.
Kind of time.
The instruction that I highlighted for the jury not to consider bipolar disorder at all, I do not believe that that was part of the agreed jury instructions. Also, I would note that plaintiff's counsel had objected to this ruling that she was going to make during the portion of the transcript where they were making their directed verdict arguments. When the trial court asked, "Can you live with this?" plaintiff counsel said, yes. I mean, he had already made his arguments. He was not obligated to continue to argue that.
Thank you.
Thank you.
Thank you for your presentations today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted to our website and that of the Supreme Court.